This is in the District Court of Butler County, Kansas, case entitled In the Matter of the Marriage of Jessica Ferguson and Timothy Ferguson, case number 2024 DM 13. The petitioner, Jessica, appears with her attorney, Karen Patterson. Respondent, Timothy, appears with his attorney, Susie Locke. This matter comes before the court at this time for a status hearing. Mr. Patterson, what is your current assessment of this case?
Your Honor, as the court stated, this is a status conference. I would tell the court that our request to the court today would be that we use this as a case management conference to set dates and deadlines. We are wanting to get this case finalized as soon as possible. This is a pretty low asset case, so that there's not a lot of asset and debt issues from our point of view. From our point of view also, I don't believe that formal discovery is needed, so that unless requested, I'm not sure we need a discovery deadline of any kind, that it would just be ready to set for pretrial conference if need be, if it can't be settled. I know that the answer that was filed had certain requests in it, and I think those need to be addressed here today. One of those requests in the answer was that there was a request for or a denial that the parties were incompatible, a denial that there's irreconcilable differences, and a request for marital therapy. I would tell a court my client is wanting to exercise her statutory right to a divorce, is not wanting to entertain marital therapy, is just asking to have the case set to finalize and move forward. So that's where I see the case at today. We just need to set dates to finalize it or move towards settlement.
All right, Ms. Locke.
Your Honor, I don't disagree with Mr. Patterson's position. Unfortunately, my client has not seen or had contact with the minor child in this case since January. There is a pending criminal action with a no contact order in municipal court that will hopefully be resolved on July 10th. And depending on that outcome, we're hopeful that parenting time can start. Obviously, he misses his child, but he is a witness in that case, and there is a no contact order. Excuse me. So we haven't filed any motions to modify the temporary order because that would be the basis of our motion, and we know that that no contact order is competing. I'm hopeful that when that case is resolved, Mr. Patterson and I can maybe agree to some sort of modification to the temporary order pending a final resolution in this case.
All right. Anything else regarding Mr. Patterson's view of the case?
Your Honor, since filing our answer, my client is also in agreement that the differences are irreconcilable, and we are ready to proceed to divorce as well.
All right, what needs to happen between now and pretrial conference, Mr. Patterson?
Your Honor, I'm aware that there is a trial set next week in the Municipal Court of El Dorado concerning the criminal charges that are pending. The named victim in that case is in fact the minor child. So that does kind of affect going forward what our position will be concerning parenting time, which initially we're going to be requesting supervised parenting time. Even though I'm not sure what's going to happen next on July 10 at 1:30, the date the trial is set. But we do have all the police reports. We do have the audio, video of any interviews. We are prepared to present that if need be at a motion to modify temporary order if we can't come to some agreements later on. But as far as our request for moving forward, Judge, again, there's not a lot of assets here, so we don't think discovery is needed. We just need a pretrial conference date. We'll present a proposed divorce decree and settlement to the respondent before that date to see if we can get it settled, but otherwise we just ask to move forward.
What is the charge pending in municipal court?
There was
Domestic
an
violence
alleged,
battery. I'm sorry, go ahead.
there was an alleged domestic violence incident.
All right, thank you. Counsel, would an August setting be appropriate?
Yes, Your Honor.
Yes, Your Honor.
All right, I'll try to find an appropriate date. Monday, August 26th at 11 o'clock in the morning.
Judge, that's a Monday docket.
Of course, Mr. Patterson.
All right.
Set you up for a conflict. Wednesday, well, no, that's not going to work either. And so we may be looking at going on over to September if we can't use a Monday.
Monday afternoons are pretty open, Judge.
All right, let me go back and look and see if there's some afternoon settings. Monday, August the 5th in the afternoon.
I'm wide open that afternoon.
Ms. Locke? Susan, you're muted if you're trying to talk to me.
Sorry about that. I'm on Judge Merkin's docket that afternoon. It's a docket call, so I don't always know when my case will be taken up.
Okay, would you be confident that you'd be able to be present for a Zoom meeting at 4?
If it's at 4,
Yes.
his docket starts at 2:30.
Oh, I see. Okay. This is in the District Court of Butler County, Kansas, case entitled in the matter of the marriage of Jessica Ferguson and Timothy Ferguson. Case number 2024 DM 13. The petitioner, Jessica, appears with her attorney, Darren Patterson. The respondent appears with his attorney, Susan Locke. This matter comes before the court at this time for a hearing on a motion to modify the ex parte temporary parenting plan in the case. Ms. Locke, I trust you are still pursuing this motion.
Yes, Your Honor.
Mr. Patterson, is there opposition to it?
Yes, Your Honor.
Ms. Locke, you may proceed further in regards to your motion. Provide whatever additional argument you believe is pertinent.
Thank you, Judge. In March, this case, essentially a temporary order was filed, and it was an ex parte temporary order. Typically, my client would have responded much quicker once he was served the order, but there was an ongoing criminal case where he had a no contact order. That case was fully resolved in July, and the no contact order lifted, which resulted in us filing the motion to modify the ex parte temporary order. My client has not had any physical contact with his son since January 12th of 2024 as a result of an alleged domestic violence incident, which was later reduced to a disorderly conduct, for which my client is dealing with in the municipal court system. Noteworthy is some history on that incident. So on January 12th, there was some parental discipline concerns. The minor child said some inappropriate things to dad. Dad threatened to take away his gaming system. Mom and dad disagreed about the appropriateness of that punishment, and ultimately dad decided to leave the marital residence. It wasn't until February 2nd that he found out, when he was arrested, that mom had called the police and mom had reported that domestic violence had occurred when dad left the marital residence. The son was interviewed 4 days after the alleged domestic violence incident and made reports to the Sunlight Children's Home, which make accusations against dad. However, dad was never discussed those with anyone, and again was not arrested until February 2nd, a pretty significant time after this alleged incident occurred. So dad has this no contact order, follows it, does not contact his child, does not contact mom, and then gets the case fully resolved in July. Since that time, in July, when the domestic case was fully, or not domestic case, but the criminal case was fully resolved, he has had daily, for the most part, daily communication with his child via text message or phone calls. This includes nightly, like, how was your day? Have a good night. I'll talk to you tomorrow. Pretty benign communication, allowing the child to try to make that contact with dad and just get on a good firm footing with him. Obviously, he wants significant parenting time. The child appears to want that too, although dad is trying to redirect any conversations from the child that attempt to say, can I live with you? Can I have more time with you? Why am I not seeing you? Dad appreciates and knows that those are conversations that should occur between the parents or be decided by the court, and is trying to just redirect conversations with his child when he brings those topics up. So it's our position that dad should have ample parenting time, but there's nothing that is preventing him from having that time. The current order is an order for sole custody. It also attempts to say that visitation can only occur at a visitation center, which my client cannot afford to go through VEP and go to Wichita. And also, we're not sure that that's necessary for the child. And as school starts, that scheduling becomes very difficult. The other option that mom put in her temporary order for visitation is for her parents to be the supervisors. Well, that leads to a whole additional host of issues. My client states that he has never really seen eye to eye with his spouse's parents. And so to put the child in a position where his grandparents are there, who he knows have animosity with his dad, is just not conducive to a good visit. And regardless of that, we don't believe that dad needs to have supervised visits of any kind, that there has never been concerns about the father-child relationship, that any sort of issues in the marriage were between mom and dad. And those are non-factor because they've been living separate and apart for 8 months now. Dad lives in the marital home. There's concerns in the temporary order and statements that he's not in stable housing. He lives in the marital home where the child lived his whole life until mom moved him into a new residence. So he is in a stable house. He's in a house that the child's familiar with. He's in a house that the child grew up in, that has access to the same school, same friends, that the child's familiar with. So today we are asking the court to lift the very restrictive temporary order to make an award of joint legal custody, allow more open communication between father and son, and grant ample visitation. Our proposal is for a shared visitation schedule, whether that's 5-2-2-5, which is what we suggested, or a week on, week off. We think that is more conducive to a successful outcome here. I don't think any other aspects of the divorce are really going to be contested. It's truly just about parenting time.
Ms. Locke, who was the alleged victim in the municipal court domestic violence case?
My client understood that mom was the alleged victim. I think that Mr. Patterson understands that the child was the alleged victim, but it's not clear to me from the incident report who the police believed was the victim, although both mom and son were interviewed.
And I suppose the state of the municipal court complaint doesn't give any direction in that regard.
No, it just says that there's a no contact order between father and son and mom, that he can't contact any of them.
Very well, Ms. Luck. I think I understand your position. Mr. Patterson, I wish to understand yours and that of your client.
Thank you, Judge. Judge, I guess I would start by saying that there's a different version to the events that brought the sole custody order, temporary order into effect. I am going to tell the court what we would proffer, basically, if the case went to an actual evidentiary hearing, because we do have the police reports, we do have witness statements, we do have video. We have those and we can set an evidentiary hearing and present it. But as a proffer, I would tell the court that it is correct that he was not arrested immediately when these things occurred, although the police were called immediately. That's because he ran, he left the scene, and he was nowhere to be found. So he was arrested on February 3rd, 2024, when there was a alert of where he might be. Police went there, did find him there, placed him under arrest, and at the time he was placed under arrest, there were drugs found on him, 2 high tides THC vape carts with 92.6% THC. KBI lab report was completed and positive for that drug. That's one of the issues my client has had, is that he is a known and active drug user of illegal drugs. And by allowing the unsupervised visits that he does this all the time, she's concerned about her son being exposed to it. So there is proof of the drug use. On the date of the occurrence in January, I would tell the court that my client made a written statement. The child was actually taken to Sunlight Advocacy Center, and there's a video statement of his, but the summary report indicates that the child saw his mother being taken to the ground by the father, and then the child went over to try and rescue his mother, and the child stated then that he became the center of the attack, and here's why. In the reports, it does state that there was an argument going on, and that at some point my client was pulling out her phone to call the police. The respondent then basically, attacked her to get the phone away. They struggled. That's when the son got involved. My client yelled at her son to take his phone out, call the police. That's when he turned on the son and took his phone. The son started to run to the neighbors. The respondent said, "Stop. We don't want anybody else involved here." And then he left. 911 was called, however, and they did have this report with the interview at Sunlight Advocacy Center. There is evidence and facts that back up what my client has suggested happened. We're aware that the municipal court has these charges. They've taken care of the charges. In fact, I have the disposition sheet here. Disposition sheet does show that there were originally 3 charges: intimidation of a witness, unlawful restraint, and domestic violence battery. And then also possession of marijuana, possession of paraphernalia in a different case number. That as a result of plea negotiations, the drug charges were dismissed completely. That the intimidation of a witness was dismissed. That the unlawful restraint and the domestic violence battery were both amended to disorderly conduct. There are fines and costs and a jail sentence that is suspended. He was placed on a 1-year reporting probation with probation officer Ryan Smith. What I guess I'm shocked about that is that there are no special conditions of anything to do with drug and alcohol assessments, nothing to do with drug and alcohol treatment, nothing to do with batterers intervention assessment, nothing to do with anger management. Those are all blank on the dispo sheet. So my client did not agree with the plea negotiation when they asked her, but that of course is a prerogative of the prosecutor. So these are the things that happened, and the son was right in the middle of it and subject to it. My client states that the police have been called over the period of their relationship. It's in the teens because of violence, the such like that. And she tells me the son has commented how peaceful it is without the father around, no arguing, no hitting, nothing. So I think that says a lot. My client is concerned about unsupervised visits unless he gets at least either a mental health assessment, anger management, a BIP assessment, because this is not something that is isolated. It is an ongoing issue. My client's also concerned about the drug use without a hair follicle test to show that. And if it's positive, a drug and alcohol assessment. She's certain it's going to be positive. When it comes to safety issues, that's safety issues, but there's still other issues that are concerning to her, and that's the residence that he currently lives in. She lived there too, but she also was the one who was trying to help the mice infestation situation by cleaning up the feces that were in cabinets, by cleaning up the feces that were in the bathrooms, by trying to get the mice. But she said as she got closer to the time that she moved, the infestation got worse, and it's just an unhealthy place because of the infestation. She doesn't know if that's changed or not, but if it's the way it was when she left, she does not think it's a healthy situation. It is a 2-bedroom house that it's her understanding the respondent took on a roommate. She is not aware of the full name of the roommate to know what his circumstances are, if there's some kind of background that should be done on this new roommate. So there's unknown question about the roommate, but further having a roommate, then where will her son sleep? That's getting to be a question for her too, if there's to be an overnight. So that is concern about the house and the living situation. But all of this is in the temporary order that is currently before the court. Judge, I would also tell the court what's in the temporary order is a child support amount. My client, since moving out, has taken full responsibility financially for the child. She has received nothing. She has been working towards trying to get school clothes, supplies together, but has received no child support. There's approximately $2,915 in arrears currently, but she is forced to make ends meet on her income only for this child. So it has been a struggle for her. Judge, I can tell the court what she would agree to here today based upon the history, based upon what I've just went through at the court, is she would not object to changing the sole to joint so that they can both have information and know what's going on. But the parenting time is her main issue, and that she believes it should continue to be supervised until he does some things that frankly, the municipal court maybe should have done. And that's order either, again, a mental health assessment, a BIP assessment, or at least anger management, that there be hair follicle and follow-up drug and alcohol, and that he be drug-free. But if there is going to, and before I go on to the next, there was a suggestion at one point of a different supervisor by the respondent through counsel. And that was Steve Waite. That I don't know if that's still their proposal, but we would have opposition to that if that's still a proposal and would want to be heard on that. Judge, if the court elects unsupervised, we would just ask no overnights at this point. That the house needs to be inspected. We need to know who the roommate is. We need to do some background checks. My client's also worried about his friends because they basically partake in the same activities that the respondent does. The allegation in the motion is that my client won't allow phone calls, but she doesn't interfere with that. She's fine with the phone calls. She would say that he is very sporadic and not all the time. In fact, when I met with her getting ready for this hearing yesterday. She told me it's been at least been a week since there's been any phone calls. So she's not interfering with phone calls. She's fine with that, so they can have contact. She's not opposed to, if there is a need for exchanges, to be a Quick Trip, a public place. So there is a no contact order in the current temporary order. We would ask the court to amend the temporary order to allow contact, phone, text, email to discuss child-related matters, but needs to be peaceful, and in-person contact only for purposes of exchanges and matters concerning the child. So those are her concerns. Those are our positions on it, Judge.
Very well, Mr. Patterson. Ms. Locke, I've got a number of points I need you to address here. First of all, why hasn't your client paid child support like he was ordered to do?
Your Honor, financially speaking, that is very difficult for him to make the current ordered amount. And I'll be honest, he needs to start paying something, but that is a challenge.
So he hasn't paid anything in child support?
I didn't know where to.
He has not, but we will have a more robust discussion about that after this hearing, although it is, I can't quote a direct case, but child support payments are not supposed to affect parenting time. And we're before.
Well, I understand that, Ms. Locke. I'm just saying that if he doesn't start paying the child support that he's been ordered to pay, then he and I are going to have a robust discussion.
Understood, Your Honor, and it is a temporary child support order, and so those any arrearage, any future payments would be taken up at the final hearing, and he understands that he will have an obligation to support his child, and he is prepared to do so, but the current amount is not something that is feasible for him.
All right, well, that issue is not narrowly before the court today, so let's move on to the next issue, this roommate situation.
Your Honor, my client does not have a roommate. The house is suitable to live in.
Okay, go back to the roommate. We're just focusing on that. Why would the mother think he has a roommate? Is there somebody that stays over there on a regular basis?
I did.
He has had people that have come and stayed in the house, but there's no one that lives in the house with him. And it is no one that would be any sort of harm to the minor child. It appears that mom wants to pick every part of my client's life apart. However, he has to afford to live in the house that they lived in previously on his income alone, and he does not have a roommate.
Okay, just find it interesting that he can put up other people and support them at least overnight, but he can't pay any child support for his child. But all right, but you're saying that no one is a regular inhabitant of that house. Is that correct?
Correct. He would like that.
Okay.
He would like for that to be his minor child.
All right. So he does have bedroom space for his son, correct?
Yes.
Okay. Drug use, address that.
Your Honor, my client is on reporting probation with Ryan Smith, who is a very serious corrections officer and takes that very seriously. So to insinuate that he is actively using marijuana would be inconsistent with his probation, and he reports to Mr. Smith regularly and is subject to random drug testing. There is prior history, and he won't deny that, but he's actively not using any sort of substance. And that it would be consistent with his requirements to not go to jail.
Right. Even though I'm creeped out about this discussion, what about the mice infestation allegation here?
We lived behind a field, like my house is right by the school.
Yes,
Their house
backs up to Blackmore Elementary. And they have had pest control trouble in the past, but he tells me that it's not an active issue at the moment. And it would be noteworthy that mom resided in this home for the child's whole life until she unilaterally decided to leave and take almost all of the possessions out of the home. So it was not a big enough deal during the marriage for her to want to leave, but now suddenly that dad wants parenting time, it is an issue that needs to come before the court.
All right. Since it appears that it's conceded that this has been an ongoing issue, what is he doing about mice infestation issues currently, if anything?
What everyone would do, which would be just traps, bait, those types of things to make sure that your home doesn't have any rodents.
Are there other animals in the house?
2 dogs.
There are 2 dogs that also reside in the house.
One's a son's dogs.
Maybe you need a cat. All right. Very well. Mr. Patterson, I wanted to give you an opportunity, since I had asked perhaps about some matters that she hadn't spoken of before. Anything else from your perspective?
Just as to the drug issue, Your Honor, my client would offer to prepay a hair follicle and a UA, and so that he could go to Assured Occupational Solutions and get that done today, and we can know for sure. It's my understanding, having talked to Assured Occupational Solutions, is that the hair follicle will reach back approximately 90 to 100 days. So that the arrest was in February for that. If he's not been using, he should be clean all the way around. So that she would agree to prepay that, but have the court consider repayment if he's positive later.
Well,
Other than that, Judge, we heard their arguments. We still hold to what our requests are to the court.
Your Honor, may I respond to Mr. Patterson?
brief.
Finding. Prior to this incident in January, my client was a regular fixture in his child's life. Since January, he has had virtually no contact with him, which is not healthy for a teenage boy to not have contact with his dad, who he had a very positive relationship with. Mr. Patterson is asking the court to put parameters on my client that are similar to a child in need of care case, despite the 11 years. So we would ask the court to make reasonable parameters, but also strongly consider the idea of regular and consistent unsupervised visitation.
Very well, Ms. Locke. Mr. Ferguson, the only reason we're here and the only reason you have restricted parenting time with your son right now apparently is due to your, let's call it for what it was, which led to the municipal court case. Obviously, this was an extraordinary situation when this case was filed because there was an intervention from another court that placed restraining orders on you, which interfered on what this court would have otherwise ordered or necessitated as part of reasonable temporary orders in the case. The municipal court case is now resolved, apparently, Mr. Ferguson, very favorably to you. You have disorderly. It essentially looks at this point, and I think at least consistent with what's in the best interest of this young man, reinstitution of a relationship, a more normalized relationship between father and son. Mr. Ferguson, it's not good for your son, in my opinion, to be totally separated from you. Nor should you have to just settle for whatever small breadcrumbs your wife is willing to throw you. So I want to work toward separated from him for a period of time. Are you free this evening, Mr. Ferguson? All right, I'm going to want this boy delivered to the McDonald's restaurant in El Dorado at 6 o'clock tonight for you to spend a 1 hour time with him at McDonald's.
Okay.
Now, patronize the restaurant and buy him dinner.
Okay.
I don't want you to just use their facility for free. I want you to use the
Right, I
restaurant for free.
understand.
For 1 hour, I want you to visit with him. Mother can be in the restaurant. She's on her own. I want her at least 15 feet away because I want you to have an exchange with your son where she's not interfering. in any way, I have no doubt that you can have a reasonable and peaceful conversation with your son and maybe talk over a few little things about getting back together or whatever's going on in his life to make him comfortable with being in your presence again. Obviously, the request for shared custody is going way too far, way too fast. We have to crawl before we can learn to walk. So I think what's going to happen is that I'm going to institute the phase-in plan in paragraph 9 of the motion in this case. And I'm going to try to normalize things. I'm not going to require supervision. I find the whole supervised visitation thing to be untenable for any number of reasons. And based on what I've heard, you had a bad incident and it involved his mother. You two apparently don't get along very well. But what we're trying to do is look at the relationship between you and your son, and you have to make it work. Now, I don't expect that you let him get by with whatever behaviors he thinks he can get away with. He has to have discipline, but it has to be reasonable in its scope. You understand that, Mr. Ferguson? And you have to make. Look, at this juncture, if you had a positive test for THC, I don't know what that would tell me, except that you're still continuing to use marijuana or its products. I don't think that that makes you a better parent. It certainly may make you a worse one. I would implore you to stop it and stop it completely. And I will say this, I don't want this young man exposed to this in any way, shape, or form. It's harmful to him and harmful. I don't want you under the influence in any way anytime you're around him. Not to mention the fact that this use is illegal and you're on probation. And I don't know why you'd want to take that chance to go to jail or lose rights to your son. So that's got to stop. I want you to stay on top of this mice infestation thing. And if it takes outside intervention from an extermination company, that's what you need to do. Okay? And you need to pay your child support as you've been ordered to do, at least to the best of your ability. And I can't believe that the best of your ability is zero. So after this McDonald's visit tonight, I think the parenting plan proposes Wednesday evening. So there will be a little break before next Wednesday, before you exercise parenting time unsupervised with and interactive as they can be. And I'm going to also order the every other weekend unsupervised visitation. We need to see how this is going to work, Mr. Ferguson. But I think that after 2 shorter visits, maybe it's time for you to start seeing your son on weekends. But I want a clean house, and obviously, you know what my opinions are regarding the mice issue. So you've got to make sure that the place is cleaned up and ready for him each and every time. If he wants to call his mom during your weekend visits, he should have the right to do so. Things are going with him. And a daily check-in visit, either initiated by your son or by her, seems entirely proper to me. So you need to make sure that that's facilitated. I understand the request for testing, but again, I think my opinion is the presence of THC in the system that may be 3 to 4 months old doesn't necessarily tell in relatively short parenting time periods. Just as long as you're not smoking or under the influence when you're with him. And I do hope that you are getting regular UAs from your probation officer. I think he would be very interested in any violative behavior, as would this court. All right. As far as exchanges is concerned, what is need to be peaceful and non-harassing, as Mr. Patterson alluded to. All your communications between the two parents just need to be regarding your son. Anything else should go through your attorneys. Any other discussions you have about the case, which I hope someday gets toward a final resolution. This case is 4.5 months old. So I hope the attorneys are at least working together on all of the other issues of this matter. And we are going to have a pretrial conference in this case on resolution of issues at that time.
Your Honor, our order or our motion proposes that the parties would meet at Quick Trip in El Dorado. It's a public place. It's frequented by law enforcement officers, and we feel like it would be a safe and comfortable spot to exchange.
That
Any
is
opposition to that, Mr. Patterson?
no opposition, Your Honor.
All right, very well. I find that to be appropriate. You might want to consider all right. Mr. Ferguson, you've been restricted for a considerable period of time. The court has lifted many of those restrictions. You need to make it work, though, between you and your son. I think he's going to look forward to spending time with you. I suspect he's missed you and missed you a lot. So I hope that you can identify the activities that you and he can do with you as good as they can be. This has been tough on him, without a doubt. And the mother is just trying to look out for his interests. All right, Ms. Locke, is there any other aspect of the motion which you believe the court has not yet adequately addressed?
No, Your Honor, and just for clarification, tonight will be
Correct.
my only request would be at the pretrial conference, if Mr. Patterson and I don't have an announcement, that the court would hear a report on how visitation is going and consider additional visitation at that time.
The court will definitely want the report regarding how parenting time is going. Take under advisement whether this court would be inclined to expand any visitation rights after just 3 weeks. Is there anything else regarding clarification of the court's current orders that you need?
Judge, I will prepare an order directly after this hearing, so I just want to make sure I do have it all correct. I do have this evening at 6 p.m. McDonald's for 1 hour, but I wasn't trying to not listen to the court. I missed the other visitation, so I want to make sure I have that correct. What
I was
is
going to
it?
put the responsibility. Ms. Locke, did you want him to do the order?
I also appreciate his volunteerism. I'm sure Mr. Patterson and I can work together to make sure the order reflects.
But if you need any further clarification from me,
I did, Judge. The after tonight, what was the next visitation the court was ordering?
next Wednesday.
And that would be from what time to what time?
Well, it's set forth specifically in paragraph 9 of the motion.
Okay, that's
And we're just talking about paragraph phase 1 at this point. I'm implementing phase 1, paragraph 9A of Ms. Locke's motion.
and I will put that in there, Judge. And I just wanted to also follow up as to the provision of the current peaceful by text and otherwise, and then in person for purposes of the child.
Yes.
Okay, and then the court did, in its recitation of the general situation of the case, stated that discipline needs to be reasonable, that there should be no illegal drugs by either party, and mice infestation should be managed. Or that the court did make those orders also.
Yes.
I believe that's all I have, Judge.
All right. Again, I'm sure Ms. Locke greatly appreciates you drafting an order promptly and getting it to her for her review. The sooner we get this order on file, counsel, the better. And I do hope that the parties can communicate in a very reasonable way on anything that affects their son and his welfare. It's something you're going to have to do for a long period of time. So I hope that you can start parents. So good luck in that regard. Again, we'll conduct further proceedings 4:00 p.m. on August the 26th. If there's nothing further, then the Ferguson matter will currently be in recess, and this meeting may be ended. This is in the District Court of Butler County, Kansas, case entitled "In the Matter of the Marriage of Jessica Ferguson and Timothy Ferguson," case number 2024 DM 13. Darren Patterson appears on behalf of the petitioner and with the petitioner, Jessica Ferguson. Susan Locke appears as counsel for Timothy, who joins his attorney in her office. This matter comes before the court at this time for further proceedings. Mr. Patterson, where are we in this case, and where do we need to go?
Judge, there have been some recent discussions. I think I would defer to counsel to kind of let us all know kind of whether we're closer or not.
Sure, Judge, I think we have an agreement on a parenting schedule. That would be the permanent parenting plan in the case. I think the only issue that we have a hiccup on is some marital property, one piece of marital property in particular. I'm hoping that Mr. Patterson and I can work that out, and hopefully we can resolve this fully by agreement.
All right, how much time will be necessary to finalize these negotiations and settlement?
Judge, I would tell a court, based upon that statement by counsel, of course, this one piece of property that's being discussed by counsel is a four-wheeler. It no longer exists. It's been sold. But if we're going to get into that, then it gets into many other vehicles that we're going to allege the respondent has or disposed of. And we're going to get into a bigger mess at that point. So I'm hoping we don't have to get there. I'm hoping we can move on with our original settlement that was discussed and let those things lie and move on. But if not, then I probably do need to do some discovery real quick and get that out immediately. We're talking several motor vehicles that we allege that he had, and now they're missing. They've been moved. So something fishy going on, but I'm going to have to at least do some due diligence into those vehicles.
Ms. Locke, any reply?
Yes, Your Honor. Our concern is with a four-wheeler. Obviously, my client had a no contact order with the petitioner when she first filed the petition. When he returned to the marital home, when he was finally able to do so, it was virtually empty and devoid of all marital assets, including a four-wheeler that he had built with his son. So the only thing that we're requesting is to know when and how the four-wheeler was sold and what the proceeds went to. Mr. Patterson has told me that the four-wheeler was sold, but we're just asking for some proof of the sale. A Facebook Marketplace screenshot would suffice, just so we know when and where it was sold. Beyond that, we don't really have any other contentions. Obviously, we will if we go into full-blown litigation, but just proof of the sale of the four-wheeler would be sufficient for our purposes.
Why would that be a problem, Mr. Patterson?
It's not, Judge. In fact, I have emailed Ms. Locke with that information. My client, and I'm going to look at my emails real quick. My client sold it February 17, 2024 on Facebook Marketplace. I've never done Facebook Market, so I had to ask her how that works. And basically, she puts an ad on Facebook. She got a response. She made the sale. Then she deleted the ad because you don't want to continue to get people to call you, contact you. It's gone. She doesn't have that ability to print out a Facebook ad at this point, but she did take that money. Part of it was used to pay a water bill, which she has the receipt for. It was the party's water bill from where they live that she had to get paid. And she said it was around $200 total over that was several months worth. And then also the rest of it was deposited into my client's mother's account because my client didn't have checks. And we can get that canceled check or deposit probably. And then a check was written out to Steve Waite, who was their landlord, and we can get that canceled check, which accounts for all she sold it for. So we can provide that. But beyond that, Judge, I'm not sure why that is going to be an impediment to getting this case settled.
Well, if that documentation is readily available, it should be provided to the opposing party upon their request.
Sure.
So hopefully you can do that, here in due course, Mr. Patterson. A little
Yes,
bit of
sir.
work, and then maybe Ms. Locke and her client would then be satisfied that the sales proceeds went to a legitimate purpose.
Yes, Judge, we'll provide those.
All right. Well, I don't perceive that we need to set a hearing too far down the line before we can perhaps review this case for perhaps the final time and have a final hearing. So I'm going to go ahead and set a date in September, if I have one. Monday mornings don't work well for Mr. Patterson. He has a big contract responsibility on that day. I'm sure my assistant will straighten me out if she's booked anything here at this time. Friday, September the 27th. Almost exactly a month from where we are.
Judge, I apologize. I am in Florida with my son for an engagement party.
All right, that's fine, Mr. Patterson. I hope you enjoy yourself. Sure you will. Again, Mandy, do we have Tuesday, October 1 at 3? I trust you'll be back, Mr. Patterson.
Yes, Your Honor.
Judge,
October 1 at 3 work for you, Ms. Locke?
I am on the sync docket at 3.
Okay.
I'm available earlier in the afternoon if the court is.
Can't do earlier in the afternoon. Perhaps 11:30 that morning, Tuesday, October 1 at 11:30.
I can do that.
Also on the sync docket.
Okay. All right. Just hate setting this too far out, but I start running into jury trial settings, both civil and criminal. The judicial conference.
So when is the judicial conference, Judge?
Judicial conference council is October 10 and 11.
Thank you.
Closed for a holiday on the 14th. Tuesday, October 15, now at 4 o'clock.
I'm open.
I am not available, but we will have another attorney in our office at that time, and I will have him cover the hearing so that it doesn't have to get bumped out so far. But hopefully Mr. Patterson and I are in agreement, and he's the only one taking testimony of his client.
Okay. Thank you. I appreciate that accommodation, Ms. Locke. I'll set further hearings in this Ferguson matter for Tuesday, October 15, 4 o'clock p.m. Again by Zoom. And again, encourage parties to exchange information and further confer to try to reach a total resolution of all issues in the case. And we'll look at the case again Tuesday, October 15, 4 o'clock. That will be a Zoom proceeding.
Thank you, Judge.
Patterson, anything further at this time?
No, Your Honor.
No, Your
Ms.
Honor.
Luck, anything further? Okay. Then the Ferguson matter will currently be in recess, and this meeting may be ended for all this time. Have a good afternoon, folks.
Thank you.